So let's go ahead and get started. First of all, I want to welcome everyone to this edition of Morning Fuel. As you well know, that these special webinars are put together when we couldn't get together. We're hoping as more folks get vaccinated and we get ahead of this terrible pandemic, that we will be able to get back together again real soon. We have an Alliance event that's coming up in April that's outdoors and we can social distance, and we look forward to seeing as many of our folks there as we possibly can. I'll mention that again at the end of the show. But for your recollection, your cameras have been turned off, your mics have been muted, and we'll be using the chat function to forward any questions to the panelists today. Really do appreciate our guest this morning from Ball Morse Lowe. You will recall that we had Ball Morse Lowe on immediately after the MCGIRT versus Oklahoma decision. Stephanie was great with her characterization of the lay of the land at that point. They have been very helpful to the Alliance as we sort of navigated our comments back to the federal congressional delegation, and have been just a big help to us. So thank you, Ball Morse Lowe. Today, we hear from Stephanie Moser-Goins and Will Hauser on contract modifications for companies working in Indian country. And Will Hauser is the Energy Director for Ball Morse Lowe. Before joining Ball Morse Lowe, Will served as an in-house advisor for an independent global energy company specializing in E&P and led energy law firms in both Denver and in Houston. Stephanie is currently a senior attorney at Ball Morse Lowe with over a decade of practice in tribal, state, and federal jurisdictions. She's an expert in oil and gas title examination and Native American natural resources. She regularly fields questions from clients pertaining to Indian title and jurisdictional issues, as well as development of natural resources in multiple tribal, state, and federal jurisdictions. Will and Stephanie, thank you very much for joining us. I'm going to allow you guys to sort of kick this off and tell us what we need to be thinking about, what our member companies need to be considering in this new world.
Thanks, Brooke. Thank you guys for having us, all the members that are joining in today, and give Stephanie a little extra praise for putting this presentation together and sharing her expertise with us. She's definitely a great asset for us here at the firm. As you know, we're getting a lot of questions after the MCGIRT decision about, how will this affect our operations? Of course, we're largely committed to representing E&P companies. So a lot of the questions we are getting concerning are on the environmental and regulatory side, how those things are changing, or if they will change the taxation issues. And so when we discussed this presentation, I kind of asked Stephanie to lay a little more groundwork. And for those of you that are well-versed in this subject, if we're guilty of starting a little too soon in the educational process, that's all on me. But I know a lot of times when I'm having discussions with clients, a lot of the basic questions aren't understood. So we kind of want to get that ingrained in everybody's mind as we keep talking about this issue, so we can really have a solid discussion as it gets more complicated as we go on. I think we're all aware that this won't be an easy legislative fix. Doesn't look like it's going to be fast by any means. So reminding ourselves of how we need to operate in Indian country, even before MCGIRT, but definitely post MCGIRT, is pretty important as we move forward. With that, I'll quit talking and let the expert have the floor.
Thanks, Will. Can you all see my screen presentation right now? Okay, excellent. Well, thank you for having us. One of the things about anytime you're working in Indian country is that the field of federal Indian law is very, very specialized, and some of the foundational principles go back centuries. So one of the things that will help it make a little bit more sense, if we just take a few minutes here to give you guys the background of some of the foundational cases that inform everything that we're doing now. When you're working in the field of Indian law, you'll hear a lot of discussion about the Marshall Trilogy. These were some of the earliest cases in Supreme Court history, and they dealt with issues of Indian title starting with the doctrine of discovery that established basically the foundation for Indian property rights and for Aboriginal property rights in what is now the United States. And basically those property rights are characterized as rights, something less than full fee, that basically upon discovery, tribes retained rights of occupancy and possession, but the power to alienate their lands was defeated by the discovering entity. There are a couple of other big cases in the Marshall Trilogy that we rely on, and that you really have to understand the background for this to make sense. The first is Cherokee Nation v. Georgia. That set the foundation for the guardian ward doctrine by characterizing tribes as what we call, what the Supreme Court called something like domestic dependent nations, is exactly the language that John Marshall used. And basically what that means is that tribes, the legal characterization of tribes is as an entity that is dependent upon the United States for protection. And so it became later on, it informed some of the case law establishing what we call the guardian ward doctrine, which is the foundation for the establishment of the federal trust responsibility to tribes. And that's important to understand because breach of trust suits filed by tribes against the federal government is the main legal mechanism for enforcement of tribal rights. So the next case then we get to was Worcester v. Georgia. That established a foundational principle that absent any other law to the contrary, state laws generally have no force in Indian country, right? So what that means is that in practice, when you are looking at questions of state jurisdiction, whether or not state law is applicable within the boundaries of Indian country or within any particular tribal jurisdiction, you have to look for an act of Congress that specifically delegated that federal authority or conveyed that to the state. And there are lots of examples here, particularly with the 5 tribes in eastern Oklahoma. There are lots of examples in which Congress did in fact give Oklahoma state courts jurisdiction. So anytime you've ever sought a lease approval, the reason, for, Choctaw, Chickasaw, Cherokee, Seminole, Muskogee Creek Nation, you can do that in state court because we had these specific acts that conferred jurisdiction to state courts to adjudicate some of these issues. There are examples in which Congress specifically granted state jurisdiction over taxation. So there are also examples, and one that we've been dealing with a lot recently is, OCC jurisdiction over 5 tribes' trust and restricted lands. That's another example in which Congress specifically gave the state of Oklahoma jurisdiction in this particular area. So bear in mind that Congress has plenary authority over Indian affairs. That means it's, the only other field that I can think of off the top of my head is immigration law, where Congress has a really broad power to legislate in those matters. So the other thing you need to realize is that the tribal status that I mentioned earlier as domestic dependent nations and that trust relationship with the United States results in some very specific canons of construction that apply to interpretation of the treaties governing that relationship between tribes and the United States. And they also, these special canons of construction are also frequently used in contract interpretation. And that is, language generally is when a court is adjudicating any questions about contract disputes, that language generally gets interpreted very liberally in favor of the tribe, and ambiguities are going to be resolved in favor of the tribe. So bear in mind, anytime you are dealing with these matters, that there are special canons of construction. The other thing too is when we talk about Indian country, that is a term of art, and it's important people know that there is a statutory definition of that in 18 USC 1151. You'll notice that's in the criminal code. And these three areas are basically three subsets of three definitions of Indian country. The one for purposes that we're concerned about post-McGirt is 18 U.S.C. 1151A that defines all lands within the limits of any Indian reservation, notwithstanding the issuance of any fee patent. That includes fee lands and including rights of way running through the reservation. So this is the underlying legal foundation why we're looking at these issues through McGirt. And although this was initially a criminal statute, it was subsequently incorporated for purposes of civil jurisdiction by the Supreme Court. So, you know, back to in McGirt, we have the holding of McGirt that essentially the Supreme Court said that the boundaries of the Muskogee Creek Nation Reservation had never been disestablished. And so all of those lands within the boundaries fall within the definition of Indian country. And yes, there is language in Justice Gorsuch's majority opinion that says, yes, this looks like it's limited to criminal jurisdiction, but it does have effects because there are numerous federal laws that have incorporated that definition, incorporated the statutory definition of Indian country into civil legislation. Generally, when you're looking at these tribal disestablishment cases, the courts are analyzing allotment acts, treaties that govern the removal of these tribes to, in this case, Oklahoma. And I thought I'd give you an example of what, you know, we've talked a lot about the ambiguities you know, under McGirt, there's a lot of discussion about the allotment act language and why the Supreme Court did not see that language there. I thought I'd also give you an example here of language that the court does look for when they're trying to figure out whether or not a reservation has been disestablishment. The Oda, Missouri, and the Ponca reservations are examples that I like to provide people for examples of that clear language that they're looking for. So what changed under McGirt? Well, title to real property doesn't change, but there are indirect effects on civil jurisdiction, and that's what we're dealing with now, right? So bear in mind, though, that, and the Supreme Court was very aware of this and talks about this, the tribal jurisdiction over non-members within the boundaries of a reservation is subject to very well-established jurisdictional limitations that the Supreme Court has imposed upon non-members. And you hear a lot of talk about Montana exceptions. Well, those exceptions, let's kind of go through those right quick. There are two big principles under Montana, the two big exceptions under Montana. What Montana said is that generally a tribe's inherent power to exercise civil jurisdiction over conduct and activities within the boundaries of its reservation is limited as to non-members. So generally there's a presumption that that power doesn't extend to the activities of non-members, absent two exceptions. And one of those exceptions, Montana 1, is what we call the consensual commercial exception. That is when non-members enter these consensual relationships, i.e. contracts, through commercial dealing, contracts, leases. Those types of consensual commercial relationships is what we call Montana 1. That's the exception, was yes, I'm going to do business with you, and when you enter a contract with a tribe or a tribal member through these types of dealings, that is where that Montana 1 exception kicks in. And then the second exception is basically conduct within its reservations that is considered to threaten or have some direct effect on the political integrity, economic security, health, or welfare of the tribe. And we don't have a whole lot of case law that really defines and puts some shade and explanation on what we mean by political integrity, economic security, health, or welfare of the tribe. Health or welfare of the tribe is probably the easiest to grasp, but what do we mean by economic security, political integrity? We don't have a whole lot of case law showing us with facts that kind of flesh out those definitions. But what we do know is that the Supreme Court has construed that exception very, very narrowly. So we know this because back in 2008, there was a case called Plains Commerce Bank. in which Justice Roberts really signaled how narrowly the Supreme Court is going to interpret this Montana exception. And basically, what Justice Roberts was really positing in this is that, look, we understand that non-members don't have a say in tribal government. They're not voting members. They don't have a say in tribal government. So, the court is very skeptical about subjecting non-members to tribal regulatory authority in absence of, consent under Montana 1. And it's important to note that's very different from traditionally the way we think about, interjurisdictional boundaries, right, between federal and states. For example, if I drive down to Texas and, to the OU Texas game, and I get stopped, making that argument, I'm sorry, officer, you can't write me a ticket because I don't get to vote here in the state of Texas. That's a lot different. Those are the kinds of notions that we're used to in traditional tribal state jurisdiction. Well, it's more limited, according to Justice Roberts in the Supreme Court. That has been more limited for tribal activity, tribal jurisdiction over non-members. So just be aware that when we are having these discussions about the effects of, how far can the tribe, how far does what's the scope of tribal jurisdiction? Know that the Supreme Court has already sort of limited that. And I'll kind of talk about taxation because I know that's one of the big questions on everybody's mind. And the body of Supreme Court case law on taxation can be really, really confusing. And that's because the analysis differs depending on who's trying to levy the tax and who's bearing the incidence of the tax and where the taxation is occurred. So generally, I'm just going to kind of put together, this is my little cheat sheet, right, of kind of categories. Anytime I'm going through and reading Supreme Court case law, this is kind of how I think about analyzing these issues. You want to look at who's trying to levy the tax. Is it the state or tribe? Who's bearing the burden? And these are the Supreme Court has established different levels of analysis. Anytime a state attempts to tax a tribal member within the boundaries of Indian country, that's where the strongest, there is a categorical bar, absent express authorization from Congress. The state can't go in and tax the income of tribal members, or basically the activities tribal members within Indian country. That's the biggest categorical bar. Now, when you start talking about taxation of tribal members outside of Indian country, then the state's power starts to expand a little bit. When the state is attempting to levy taxes on non-tribal members or collect taxes on activity or conduct of non-members within Indian country, then we have what's called the Bracker test. And that is a preemption analysis. The Bracker case involved issues of federal preemption. What that's saying is that, look, sure, state, we recognize that you have some power to tax non-members within Indian country, but if their activities concern conduct or activities with the tribe, if you're working with the tribe and you're within the boundaries of Indian country in a field that is heavily regulated, that is otherwise preempted by the United States, then the state can be barred. In this case, in what we call the Bracker test, that was forestry. The United States has a huge amount of regulatory power over timber in Indian country. And I don't think if you don't do a whole lot of work with timber, it can be kind of hard to wrap your mind up, but they have a comprehensive strategy. So in Bracker, we had an issue where the tribe had hired and contracted with a non-member to work with timber management. And I think if I recall, it was a transport company, right? So that is a field that is extremely heavily regulated. So there is an example of how a state would be barred under the Bracker test. And then when we're inside of Indian country and we have the tribe who's trying to levy taxes over non-tribal members, then we go back to that Montana test. The court has kind of adopted that Montana test for purposes of determining whether or not the tribe can tax non-members. And I could do an entire session on taxation, so I don't want to kind of get too bogged down here in the details. But that's kind of where we ended up with this double taxation problem under cotton petroleum that we talk a lot about. And
Stephanie,
yes.
sorry to interrupt. So this seems like an obvious question, which I'm often guilty of asking. So when you're entering into a contract, you need to live with a tribal LLC, let's say, you need to be aware of the taxation issue, right? And that because you're subjecting yourself to the personal jurisdiction of the territory of the tribe,
right,
you may be facing another very similar tax to what you're paying to the state of Oklahoma or what you're paying to the federal government. And where in your analysis would that, when should you be looking at that? Pre-negotiate? I mean, what is the phase? I mean, because so many of our members are going to just, they're going to be taking a tribal lease or an approved lease and then working through it that way. Yeah. And then the other thing I worry about is the trigger points of when you enter into that agreement and there was no tax structure, and then they create a new tax, which is, I think, the post-McGirt fear that we all have. And I may have asked that question at the wrong time, but wanted to get it out there.
This is where choice of law clauses, this is where your venue clauses, and this is where all of these, this is where those start to kick in. This is why due diligence is incredibly important prior. And this is the kind of due diligence that you should have already been doing anyway, right? But, in cotton petroleum, that arises under specific leases that were taken under the Indian Mineral Leasing Act. The Indian Mineral Leasing Act was the cotton petroleum case. You've got to remember this was decided under the Indian Mineral Leasing Act, right? So that specific statute didn't clearly bar the state from attempting to impose. It's like a lot of the other statutes that I showed earlier that specifically allowed states to impose gross production taxes on certain tribes. So here, first of all, you have to be aware that okay, if we're taking leases under the IMLA, okay, this is we need to be aware how are we going to handle this if given the cotton petroleum risk, right? Well, there are some solutions to this that can happen at a governmental level, both with tribes and states. What you want to include in your negotiation is, okay, well, right now, does your tribe have any mechanism in its code for credits paid to the state and vice versa, right? This is something else that can happen at a state level. And in fact, New Mexico is an example of a state that has already addressed this problem this way. So, until this is probably a good area in which, yes, a legislative fix would be possible if you could get it from Congress. And I think you'd have broad bipartisan support for that, right? Because it's double taxation. The double taxation problem is really no good for either entity, right? So if you're taking a policy of you want both state and tribal governments to be able to fund their governmental services, right? There's a really good argument that you can then make to your congressional delegation that, look, we need to get rid of this double taxation issue through Congress. You need to use your plenary power here to address this double taxation issue. Barring that, there are some other solutions that state and tribal governments can enact at their level through credits, refunds. I think Arizona, I've got an example here of where Arizona's flat out, the Arizona Club flat out excludes taxes imposed by tribes from the definition of gross income, gross receipts that are taxable. So there are some solutions to this that can happen at the state and tribal government level. And bear in mind too, that I know everybody's kind of like, well, tribal taxation, I know there's a lot of fear about that, but there is a lot of work that tribes are doing that benefits the oil and gas industry at this point, through job creation. Roads and bridges are huge, right? Tribes are getting, remember that tribes have access to federal programs and federal money through federal programs that allow them to upgrade their own infrastructure. That then has a benefit for those of us in the oil and gas industry, those of us, especially in rural areas, right? We've got to remember that a lot of our tribal nations are the main points of contact in these rural areas. The most recent example is tribal healthcare has played a huge role in helping to mitigate the effects of this pandemic. I include here an example of a tweet that, Representative Mullen made yesterday, recognizing that tribal partners have, through their vaccination programs, have already been able to kind of take some of that healthcare burden off of the state. And in fact, I saw something this morning that Cherokee Nation has actually now opened up its vaccination program to everybody living within the boundaries, within its counties and in its reservation area. So there are ways of working together. There are a lot of economic opportunities here, and you can find those when, it just needs to be part of your due diligence program and part of the negotiation, right? So when we're kind of getting down to the nitty gritty, because I know we're kind of coming up short on time here, but first of all, when we're talking about contracts in Indian country, well, what do we need to do differently? Like that's the main focus of our question here today. Well, if you're contracting with non-members and non-tribal entities on fee land, remember you've got that umbrella of Montana, because by incorporating that Montana analysis into the analysis of tribal jurisdiction for taxation and regulatory purposes, that's already going to be limited for you by Montana. So if you are not dealing directly with tribes or tribal members, you're kind of outside that Montana 1 exception. So the next step then is you just have to make sure that your activities aren't kind of implicating that Montana 2 exception. And which, I'm kind of hard pressed to think of any activities right now to provide as examples. So you just, as part of your due diligence, this kind of should have already been part of your analysis from day one, right? When you're doing this kind of due diligence, these are already the issues that you already want to be looking at. But the thing that changes in MCGIRT is now you actually have additional options for forum selection and choice of law, right? Like if you want to contract for, and I know for those of us who are attorneys, we start talking about choice of law. It takes us back to like these kind of flashbacks of civil procedure in law school, right? Which, prevents a little bit of anxiety. But bear in mind, part of the game in contract drafting and negotiation is choosing your venue, choosing your choice of law. What's going to be most favorable to you? Well, there are situations in which maybe you might benefit from maybe there might be some applicable tribal code of civil procedure that gives you a shorter or a longer statute of limitations that might be beneficial to you. You might also there are perfectly good reasons why you might want to be in tribal court as opposed to state court. It just depends on the situation. And this is why you've got to really step up your due diligence game. Even if you're contracting, when you're contracting with tribes, tribal members, or tribal entities, this is where you really, really have to seek advice for somebody who's worked with tribes before. First of all, anytime you're dealing with real property that's subject to federal oversight, you're already going to have some restrictions, some federal regulations that are going to govern what kind of contracts with some of the terms of your contracts. But even outside of, when you're contracting for other things outside, for services outside of the scope of that federal statute, first of all, if you're contracting, you got to realize you're going to be within that Montana 1 exception. So this is why you then start having to pay attention to venue and choice choice of law. And most importantly, you've got to be aware that tribes as governmental entities, just like the state, have tribal sovereign, have the power of tribal sovereign immunity. So unless you want to be in a contract that gives you a right without a remedy, so to speak, then you've got to make sure that your contract with that tribe or tribal economic development entity has very clear language in which the tribe provides at least a partial waiver of sovereign immunity that you need to enforce your contract. And you know, like we said, this is all part of the due diligence that you would do, but you also need to be aware, you know, just like you know, when you're dealing with any state or you know, state governmental entity, you know, a lot of times when you're working with states, you've got the benefit of a Governmental Tort Claims Act or something that's gonna govern resolution of your dispute. Or, you know, some tribes have enacted governmental tort claims acts but generally when you are negotiating directly with a tribe, they know that you're going to want that waiver of sovereign immunity, right? They're going to expect you to ask for that. But the other important bit of due diligence that you have to do is you have to make sure that you are clear on who has the power to waive that sovereign immunity. You've got to make sure you're negotiating with the right person, and that requires that you have some understanding about that, the particular form of government that tribe has chosen to adopt through its constitution. You know, for example, is this a government operated under 3 separate branches or 3 or more separate branches, just very similarly to the way, you know, we're used to in the United States with 3 branches. You know, in some cases you've got tribes who've got 3 branches, and I'm thinking about the Osage, in which, you know, arguably the Minerals Council would be a separate branch of government. With other tribes, especially in southwest Oklahoma, you're looking at a lot of tribes that are still organized under old constitutions that were basically provided by the federal government under the Indian Reorganization Act. And these, you know, we refer to these as IRA form constitutions because typically they provided with, you know, one central branch of government, a business committee that would make these decisions. So you have to make sure that you understand who's got the power to negotiate and who's got the power to, and what has to happen in order, do I need a special tribal business committee resolution to ratify that waiver of sovereign immunity? The other thing is you want to make sure that you've got to make sure that when you waive sovereign immunity, that the language of that sovereign immunity waiver is clear and unequivocally expressed, right? Remember earlier when I was kind of talking about some of the special canons of construction? Well, here you go. There's an entire body of case law that just is dealing with tribal sovereign immunity clauses. And you've got to bear in mind that that waiver is not going to be implied. It's got to be very clear and unequivocally expressed. So you have to make sure that the drafting, whomever is working with you to help draft that contract, understands that that language has to be clear. You have to have a little bit of special attention to that language. The other thing you need to realize is that under Cairo Tribe versus Manufacturing Technologies, you know, there is a lot of Supreme Court case law dealing with these issues here in Oklahoma, right? Because a lot of these fights happened in like the 80s and 90s, kind of fleshing with the Supreme Court case law, fleshing out the limitations of state and tribal jurisdiction. So you also have to bear in mind that when you get that tribal sovereign immunity waiver, you still need it even if your contract is going to be enforced off reservation. Because the Supreme Court has held, no, this applies. This sovereign immunity waiver, the sovereign immunity waiver extends outside of the boundaries of the reservation. And the other thing to be aware of is arbitration provisions. Now, courts have found the existence of sovereign immunity waivers in the language of arbitration clauses. So you want to pay very close attention to those arbitration clauses. You also want to make sure that whatever arbitration clause that you're incorporating, also to make sure if you're relying on that for some kind of waiver of sovereign immunity, you also have to make sure that that contract incorporates the provisions of your applicable arbitration rules that you're incorporating. You know, choice of law provisions, like I know that there are a lot of questions about, well, okay, what can we contract out of and what can we not contract out of? Well, you know, the answer is always going to be dependent upon the underlying substantive law. And remember, when you're dealing with choice of law provisions, you have to be aware of the differences between procedure. When your choice of law clauses are being drafted, you have to be aware and very cognizant of the fact that you've got to cover both procedural law. So, for example, the statutes of limitations, that's considered a form of procedural law, versus the substantive law. Well, is there an area, you know, if you're looking at trying to adopt a specific canon of substantive law, you've got to make sure that, I mean, you can't contract out of, you know, for example, you can't contract out of federal, you know, the federal regulations pertaining to timber management. It's going to be harder to contract out of, you know, so for environmental regulations purposes, right? The safety loop provisions have really limited the ability of tribes to, I mean, they can't impose more stringent regulations. They also can't impose less stringent regulations. So, I mean, just bear in mind that when you're dealing in canons of environmental regs, that particular area of law relies upon a cooperative federalism framework, which we refer to cooperative federalism. What we mean is that generally the federal government sets sort of a floor, and then the state can choose to regulate more or less stringently as long as it's above that federal that floor. So, except for the Quapaw tribe, they got their tribe to state, the treatment as a state status prior to the safety law amendment, but those provisions are going to limit the ability of tribes to be able to establish regulations that are different from state government. So, you know, again, just be aware that your choice of law provisions are going to be crucial. And aside from that, a lot of this is probably, you know, for contract negotiation. Just bear in mind that a lot of this is, you know, stuff you should have already been doing anyway. If you're already doing business with tribes, this is probably not something that's going to come as a surprise to you. But if you haven't yet had the opportunity to do business with tribes, you need to understand that there are incredible opportunities here, and you can take advantage. You are uniquely suited to be able to take advantage of those opportunities if you know what you're doing. You have somebody who is well versed in Indian law on your team who can help you navigate through these principles. So, Will, do you have anything to add? I'm kind of, that's all I have on my presentation.
Yeah, I kind of want to go maybe all the way back to around, I think slide 7, where we're discussing the OCC jurisdiction.
Yeah.
I know we're still waiting for the Supreme Court to rule on that Canaan Resources versus Calix case. I'd kind of like to touch base on that just a little. It seems to me that it missed a whole point of logic, you know, on one side of it, that the boundary issue was MCGIRT didn't change the fact that the federal government had given this jurisdiction to the OCC. So am I missing something there, or what's going on with that?
You know, and obviously I've been following this case really closely, and from what I can figure out, I think what they may be trying to argue is that the plain text of the statute, I think they may be trying to draw a distinction between trust and restricted lands. I think it's kind of hard to tell from the briefs.
Let's not give them any new arguments, but
well, no, but here's the thing. I went back and pulled the legislative history of it, and there is no intent it doesn't, let's put it this way, it doesn't make sense for the federal government to say, okay, we're giving the state of Oklahoma jurisdiction over restricted land, but not, you know, the trust land. I mean,
yeah.
You kind of fall back on, you get to the point where you tie yourself up in arguments and they start to kind of stray from, you know, the practical implications of what you're arguing, you know. So does that answer your question?
Yeah, it does. I just, and I'm not like casting aspersions on one side or the other. I mean, I obviously have my belief on, I mean, to me, it's a very expensive collateral attack on a spacing.
Yeah.
But I just wanted to kind of get that clear that the jurisdiction has been set.
Right.
And it's not to say we won't see challenges to it and that you may not have to bare knuckle some things back off of your right to do business. But I mean, that's unfortunately the way of the world right now post McGirt for some of these issues. Until it's clearly made, the Supreme Court, I hope, puts their foot down in this case and says, you know, collateral attack, you know, for all the very different reasons we could argue against the position espoused in that case.
Right. I would compliment the state and the Attorney General Mike Hunter for leaning in on that as well. I think this is critical that Stigler provision be upheld and that our member companies have clarity on that. I think that the actions that have been taken by Governor Stitt and Attorney General Hunter with regard to enacting or triggering the safety lieu provisions are critical for economic development in Oklahoma, in Indian country. The pushback on General Hunter's part when it comes to tribes who are sort of trying to make their own luck with regard to taxation letters and notifications, I think that's also critically important. So we appreciate the leadership that we've seen coming out of state officials. And we're in a unique situation where the tribes and the state of Oklahoma, we're sort of on new ground. So we're kind of working our way through the new reality. I am not optimistic that we are going to see federal legislation imminently to provide further clarity on these issues. So the reason that this presentation is so important is to remind our member companies that they need to take a look at their contracts and they need to think differently with regard to operations in Indian country. If you are working in Eastern Oklahoma and South Central Oklahoma, your legal teams need to seek advice, and you need to take a look at all of this to make certain that you know how things are going to roll forward. Will, Stephanie, any further comments on that before we jump to a few questions?
No, I agree in a lot of, I mean, certainly this decision may or may not affect the way going forward. I think it is a good time for us to emphasize the importance of the due diligence process on the front end of your negotiations. And just like you wouldn't drop over to Arkansas or Louisiana and start doing business without knowing the ground there, you know, knowing the foundation, the legal principles that may differ from the state where you normally practice. It's just very important that, you know, whether it's our firm or whoever you could choose to go to, that you get that counsel to make sure you're not going to step on a landmine. Also would like to kind of get it out there too a little bit for people to start thinking. I think Stephanie hits on it a little bit. It's not always the worst thing to be dealing with tribal jurisdiction. There are potential scenarios where it could end in your favor. We seem to have a knee-jerk response to want to avoid it. And that's kind of just the same thing. Like if we're going to go do business in Texas, I don't necessarily want a choice of laws that's going to drag me down there. So I'd say just as in always, get thorough advice, move cautiously before you spend your money.
Okay. So we have the Ball Morse Lowe final slide up with regard to the email addresses. We've had at least one or two questions on the chat line about providing the PowerPoint presentation so that legal departments and companies can review it more carefully and then ask the right questions of their counsel. So thank you for throwing that up. Will, Stephanie, are there other things that we should be touching on today that we haven't touched on? I know that we have had a letter out there, I'm hearing, but I have not yet seen it, wherein I think it's 16 tribes, including the 5 tribes, have objected regarding the safety lieu provisions on state primacy, but I have not yet read it, so I don't want to characterize it without having read it. Any insight on that?
Yeah, until I've had a chance to read the letter, I don't feel comfortable commenting on something I haven't seen.
Okay, very good.
Yeah, and I just want to kind of caution again that we need to get back to more relationship building and all levels of this, because this is a relationship we have to deal with. It's not going away. It's not going to change some drastically where it's in favor of one side over the other. So we need to work together. And I think that those companies that are taking the time to build those tribal relationships now, it's just going to benefit them in the future. I mean, there's no way you can put a dollar amount or the value on building those relationships at all levels of the folks that you're going to be dealing with out there.
They're going to have a leg up. Those companies that have already started building those relationships are going to have a huge advantage.
Great. Well, I don't see any additional questions. Cody, if you see something that I have missed, please bring it to my attention. Otherwise, I want to make certain that participants know that we have our full calendar up. Cody, anything else that you're seeing that I'm missing?
No.
Okay, very good. All right, guys. So if you will, Stephanie, would make the PowerPoint available to us, we can help you distribute that if you would so desire. Again, thank you very much for your participation today. Will and Stephanie, your insights very helpful. So we look forward to keeping membership apprised of developments as they occur. I want to remind attendees that the Alliance has set its 2021 events calendar. Registration for the Alliance Open Golf Tournament opened this week. Information can be found at thepetroleumalliance.com or look for the Alliance highlights email every Friday. I want to remind everyone about the upcoming Morning Fuel calendar, which you can see on your screen right now. We're going to talk a little bit about emerging technologies in the digital oil field with Baker Hughes. And then we're going to have Morning Fuel on April 7th with Lieutenant Governor Matt Pinnell. And again, reminding folks that the Alliance Open Golf Tournament is up there. We look forward to providing more content for our members. Let me just check one more thing before I close this down. What time and where do we meet after this for cocktails? I think that's probably the most important question. So listen, guys, I want to thank everyone for participating today. And again, this has been recorded and will be available for folks to go back through. Stephanie, Will, we really appreciate you and Ball Morse Lowe.
Well, thank you
Thanks for having us. And anybody wants to reach out, don't hesitate. We're here for you.
Thank you very much.
Thank you, guys. Bye-bye.